So I went to a conference not too long ago, and I was sitting in different sessions because I wanted to learn and I wanted to know what's going on in the industry. So this conference was for like bloggers, and this conference was for people who are collaborating with brands and doing a lot of maybe social media marketing for these brands. And I was sitting in one particular room where there was a management company actually that was talking about the contracts and not necessarily the legal aspect of it, but just how to negotiate or some of the things that are okay and not okay to do and what you can give or not give. And so a couple interesting questions came up actually. But one interesting question that came up, which I just could not stop myself and I had to answer after the main person that was speaking, answered, and I had to just chime in because I'm like, gosh, there's a lot of wrong information being shared in this room right now. But one of the question that was asked is that, well, I posted a video and I tagged the company, but they didn't have the right at the time in the contract to take that video of mine and repurpose it without having to give me, some money for it or some compensation for it. And so the answer that the speaker was giving is that, well, I think that if you have tagged someone or if you're talking about their product, then they own that video too, and they should have the right to that video since you're talking about them and their product. Now that was the answer. And sometimes like logically and intuitively, that just might seem like the right answer. But in reality and in the legal world, that is not the right answer. And let's now talk about some of the things that I took away from that one question and some of the highlights and bullet points that you actually need to think about when you are working or collaborating with companies. One of the main things that your contract, that your collaboration contract or partnership contract or social media marketing, whatever you call that contract, it should actually be highlighting usage. Usage is huge. Usage actually talks about essentially how frequently you can use whatever work product that you're creating. It also talks about where it lives, and it also talks about the frequency and the timing of it, like the length of the time that it is being used for. Now, other components of that contract that are really important also are ownership. Who owns that work product at the end of the day? And do you give that right to the brand or do you not give that right to the brand? Now, if the usage said that the brand can use anything and everything at any time that they wish that is being created on their own platform and not link you or tag you, then that's okay. But if your contract does not say that, then it's not okay. Because ultimately, if you are the one that's creating the product and you have the right to use that brand's name, trademark, and if you have that right, then ultimately that work product that's been created is yours and you're a contractor and you're not an employee, then that is even more yours because it's not work made for hire unless the contract says that. So some of the key takeaways for these collaboration contracts and things that you really need to focus on, regardless of what side you're on of the table, is one, usage. Number two, it's ownership of IP. And number three, also, it is talking about work made for hire. That's a really important clause. It's really important to know what it means. It's also really important to know if it's in your contract. And if you need more information on work made for hire, go check out the other videos that talk about that. If you have more questions, drop them in the comments below, and I am happy to answer them.